In a Connecticut courtroom on April 1st, 1985, April Fool's Day was no laughing matter. Hi, I'm Susan Langford. Welcome to another Broken Gavel podcast. In Connecticut, the phrase, an attorney should avoid even the appearance of an impropriety, was formerly part of Canon 9 of the superseded Model Code of Professional Responsibility. However, Connecticut, like most states, has since adopted what they call the modern rules of professional conduct, which do not contain that particular rule or that phrase. Here's a breakdown of how Connecticut lawyers govern themselves today. The Model Code in 1985, Canon 9, of the ABA's Code of Professional Responsibility, which was in place before the mid-1980s, included the directive to avoid even the appearance of an impropriety in the practice of law. Now, in the adoption model rules after 1986, the Connecticut Superior Court adopted the ABA's model rules of professional conduct to govern attorney behavior and removed the phrase appearance of an impropriety, hence replacing the older model rule. They claim the new model clears up any vague misunderstanding. Hogwash. Hear me? Hogwash. In my opinion, Connecticut ABA's real reasons for removing the words appearance of an impropriety was made so Americans do not catch on to the fact that lawyers sitting on the judicial review boards are policing each other because they know that's a violation of Canon 9. Some of you might ask, well, what's wrong with that? Doctors police each other on their boards. Yes, they do. However, doctors do not sit in the highest power of government. Attorneys do. Doctors do not write laws, and doctors are not responsible for carrying out the rule of law in the United States. So, I do not put doctors on the same level as I do attorneys. Attorneys need to be held to a much higher standard and need to be watched more closely by the American people. Ever hear the saying, absolute power corrupts absolutely? It's true. And that's why we need to look closely at our structure here, because corruption is out of control. Moving on to Nebraska. Now, I want to talk a bit about the organization I incorporated in Nebraska in 1992. A nonprofit known as Legal Abuse Must End, Inc. So many were helped. One corrupt law office in particular comes to mind when many people were injured by misconduct, fraud, theft, and misrepresentation by a lawyer working in Nebraska who ironically ran and incorporated his law office as a nonprofit through the Secretary of State's office. He titled his firm as Justice for All, a nonprofit law firm. Well, after my nonprofit, Legal Abuse Must End, received several complaints from community members, I decided it was time to look into Attorney John Eaker III, the owner of Justice for All. So I became his client, undercover. I signed his papers, paid his fees, and sat back watching his activity. And believe me, His corruption unfolded right before my eyes. 1 month went by when I began receiving bills from him. After reviewing the invoices, I noticed that charges were showing up, which I knew I wasn't responsible for. For example, charges for office visits I never had with him, charges for phone calls he never made, charges for phone calls he did make to outside sources that had nothing at all to do with me or my case, but had everything to do with him personally, to do with his personal life. So I let the invoices pile up. 2 months. And after that, I thought, okay, it's time to dig in. I began questioning his invoices. I sent him letters, certified letters, asking him to further explain his charges. I insisted he supply me with his actual telephone bills. I insisted he put in writing itemized details of what he felt I owed him. Then Attorney Eaker panicked because now he had to explain his actions. And trying to explain his actions was not something he was capable of. I guess he wasn't used to being questioned that closely. Well, he began using stall tactics, stalling, hoping I would go away, just give up. So he never answered my letters or phone calls. That went on for another 5 weeks, and then I decided it was time to apply the Canon Code of Ethics rules together with my arguments and file a complaint with the Judicial Review Board of Nebraska. When I did, I soon discovered I was dealing directly with one man, an attorney sitting on the Judicial Review Board who I call the gatekeeper. Yes, you heard me, the gatekeeper. Why? Because the gatekeeper was strictly and solely responsible for deciding who he would allow to file a complaint with the review board, who would or wouldn't get through his gate. When I checked the Nebraska records, it was mind-blowing to discover the gatekeeper sat on that gate for nearly 30 years. Wow, right? Can you imagine? One attorney controlling the whole operation of judicial review and misconduct as it relates to the public's well-being for nearly 30 years. You know, that in itself is a violation of Canon Code 9. Remember, an attorney should avoid even the appearance of an impropriety in the practice of law. Talk about complacency. Look, when you sit with that kind of power in the same state, you often become arrogant. Well, that was the experience I had with the gatekeeper. Who is he? Attorney Dennis Carlson, now a retired gatekeeper. I hope no repercussions come to my door for giving out his name. Anyway, he immediately dismissed my complaint, said the evidence I submitted was nothing in his opinion, and tossed it right out. Okay, I'll cut to the chase. I went over his head filing an appeal all the way up to the Nebraska Supreme Court level. Again, I submitted the documentation along with my written arguments. Well, guess what? Finally, the Nebraska Supreme Court had decided to close down Attorney John Eaker and his illegal operation. And that's exactly what they did. In addition, they ordered him to contact clients and give back the monies he was not entitled to. Unfortunately, that wasn't enough. He should have been disbarred, or at least had his license suspended for a couple of years. but nothing more was done, at least not yet. Unfortunately, the committee of lawyers decided to allow Attorney Eaker to continue practicing law and allowed him to open a new law office. Sadly, as a result, Attorney Eaker went on to harm other people, causing much more injury. As it turned out, after the closing of Attorney Eaker's scam operation, he continued engaging in unethical conduct. And he was reprimanded and suspended from practicing law on 2 separate occasions. But why did innocent people who trusted the system, trusted Attorney Eaker, have to get hurt before lawyer review boards allowed justice to occur? Now, as of this date, Attorney Eaker no longer resides in Nebraska, and no one really knows where he is. I have a letter the Nebraska Supreme Court and Attorney Allison Larson received in 1992 from Attorney Eaker. She was the actual assistant counsel for discipline in Nebraska at that time. A Supreme Court member put Larson in charge of handling Attorney Eaker and making sure he closed down his law office, Justice for All. It closed, and on November 20th, 1992, I received a copy of the letter. And in the letter addressed to Attorney Larson, Attorney Eaker confirmed his law office was in fact closed. Okay, more food for thought. Ready? This is important. When you walk into any healthcare provider's office, whether it's for dental, a specialist, eyeglasses, a general practitioner, or even a hospital, under the law, you automatically receive a patient's bill of rights and a copy of the HIPAA codes. If you have any problems with anyone in the healthcare field, you, by law, have legal rights. Those legal rights were written by lawyers. Great, that's their job, right? Okay, here it comes. Are you ready? Another case of too much power among attorneys. So, I ask, why is it when someone walks into an attorney's office, let's say for the first time, and has no experience with any attorney, but has a legal problem they need help with? All right, so they make the appointment and arrive at the law office. Why is it that the same rights and protections under the laws the attorneys wrote for HIPAA and Patient Bill of Rights, which you're made aware of as soon as you walk into a healthcare facility, but nothing is available to protect you when you walk into a law office? You're left in the dark there. And it's like walking into the lion's den. Why? No brochures, no pamphlets, no free information of any kind handed out to you, which should inform you of what to do if you have any concerns with your lawyer under your attorney-client relationship. Another eye-opener, right? I don't know about you, but I'm still waiting for equal justice, equal protections for Americans when dealing with legal scholars. There should be something available for everyone entering an attorney's law firm, a brochure informing you of your rights under the Canon Code of Ethics. Remember, I call that book the Lawyer's Bible, and for a good reason. Folks, it's time for change. If you have any thoughts on that, send me an email to langford1susan@gmail.com. And don't forget, before I wrap up this episode, visit my website for updates at brokengavel.org. Again, brokengavel.org. Next time, we're going to talk about how you prepare yourself before entering a law office, because corruption amongst legal scholars is out of control. Thank you for tuning in. I appreciate it. Stay safe. This is Susan Langford and Broken Gavel signing off.